I would have one of those. I don't seem to have I hid it from myself and Mr. Gonzalez. You ordered to stay away from 2151 these
Judge, he's not. I apologize for interrupting. He's no longer there. Corrections took him away.
Okay.
Utilize my right to be heard, and I'm representing myself, Your Honor. I just got back from the last courtroom where I was RR'd. Are you ready to hear what I have to say, Your Honor?
I am.
All right, cool. So, I would like to inform you, Your Honor, that there is 2 open lawsuits. One against this court system for wrongfully finding probable cause on police misconduct and violating my 6th and 14th Amendment and due process, which led to false imprisonment.
Uh-huh.
Against the Miami Beach Police Department for multiple false arrests where they have violated my constitutional rights and multiple United States laws. This situation is very serious, Your Honor, because I now have to file another lawsuit for attempted murder and attempted vehicle manslaughter. I say vehicle manslaughter because these 2 police officers that followed and stopped me November 6th is the same 2 police officers that watched me park my bike on 10th and Ocean, pace back and forth next to my bike on 10th and Ocean, and then hit me.
Today's video was supposed to be a jury trial, but instead what we ended up with might actually be better, because this episode delivers not one, but 2 separate courtroom disasters back to back. First, we head to Florida, where a man confidently accuses police officers, prosecutors, and the court itself of attempted murder, vehicle manslaughter, constitutional violations, and an entire buffet of imagined crimes, all while being very much alive and talking nonstop. Then, just when you think you've reached peak courtroom chaos, we jump to Washington, where another defendant manages to turn a routine proceeding into an exhausting exercise in self-importance and procedural confusion. These aren't just bad arguments, they're examples of how misunderstanding the law, weaponizing buzzwords, and refusing to listen can actively destroy your own case in real time. Pay close attention because everything that follows shows exactly how not to behave in court, and why judges' patience, while impressive, is not unlimited.
They tried to that I tried to evade them.
Uh-huh.
Tried to pull me over because if I tried to run away, why did I park my bike? And you see me park my bike on 10th Street. So look, let me continue. There's another one that I have to file for attempted murder because when they said put your hands behind your back, they prevented my hands from going behind my back while covering my face and mouth.
Uh-huh.
That is attempted murder. So now let me start. November 6th, right? And I've had this bike since February. November 6th, these officers witnessed me talking to 3 girls or whatever. They followed me for 3 blocks and then took the same right turn that I took. And then I made a U-turn onto the sidewalk and then they stopped following me. Then they approached me when I was talking to my friend on a bike lane on Ocean Drive between 11th and 10th Street. That is when they wrote the ticket. And they said, if I don't walk my bike home, my electrical bicycle, then I'll be arrested. So I walked my bike home and then went back to the same officer, Officer Rivera, after I did my research. And I told him that because my bicycle has pedals, it is considered an electrical bicycle. So if you try to arrest me for riding my electrical bicycle, I will file another lawsuit against you. And then I rode my bicycle November 6th. And no one said anything. I rode my bicycle November 7th. No one said anything. I've had this bike since February 8th. I've got pulled over for running a red light. I even called the sergeant. The regular officer and the sergeant never said my bike was not street legal. This was March. This was July where I got pulled over again. I requested the sergeant, the regular sergeant, and the regular officer and the sergeant never said that my bike was not street legal at all. So what I'm saying is, to you, you have a judicial code of conduct. You have to follow the law at all times. It's your duty to follow the law. And based on the 14th Amendment, I have the right to be treated equally. So if they're not arresting DoorDash drivers, Uber Eats drivers for riding their electrical bicycle, you cannot keep me in jail for riding my electrical bicycle. This is what I explained to the judge previously, and I got RR'd. And the public defender had did their research. They found out that with pedals, it's still considered an electrical bicycle. And I even informed this officer, and he even seen me riding southbound. He made eye contact with me November 8th on Saturday. He made eye contact with me while I was driving southbound on Ocean Drive. If I was riding something illegal, right? If I didn't go back up to him and tell him that if he tries to arrest me for riding my electrical bicycle, he will be sued. Why didn't he just pull me over? If what he said that happened on 9th Street, why didn't he pull me over? Why didn't he hop on his golf cart and pull me over? He did no such thing because that is a lie. He lied on the A form, and I'm proving it to you because I parked my bike down this 1 block away. So if I really tried to run away from the police, why did I park my bike 1 block away? And based on the fruit of the poisonous tree doctrine, anything that rooted from
This is where we immediately enter Fantasyland litigation. The defendant announces multiple open lawsuits against the court, the police department, and essentially anyone who's ever told him no. Sovereign-style litigants love this tactic because it creates the illusion of power, as if simply declaring a lawsuit somehow freezes reality. It doesn't. Courts don't stop functioning because a defendant threatens civil action, and criminal proceedings don't pause while someone drafts complaints in their head. What's especially telling here is how the accusations escalate instantly. Police misconduct becomes false imprisonment, which becomes attempted murder, which somehow turns into vehicle manslaughter. None of these claims are supported with evidence, just narrative. And that's the pattern you'll see repeatedly: loud certainty replacing legal substance. Ask yourself this: if lawsuits alone controlled outcomes, would any criminal case ever move forward?
all the charges has to be dismissed. From riding with a suspended license, I don't need a license to ride my electrical bicycle. Vehicle registration, I do not have to register my electrical bicycle. And driving with a license suspended, I don't need to have a valid driver's license to ride my electrical bicycle. And this all
Judge, on his traffic case, he received RR.
Well, good. Anyway,
yes. So what I'd like to say is that also Burger King is across the street from the police department. So no police officer can say that they don't see other electrical bicycles and other dirt bikes riding on the beach. So it's no excuse, not even just pouring it out, that they lied on an A form. And it's all the workers. I even have a video. There was electrical bicycles passing by November 6th as they was writing me a ticket for my electrical bicycle, which was a blatant violation of my 14th Amendment. So they continued to write a ticket for my electrical bicycle as someone pulled over and said, "What's going on?" A restaurant worker that usually parks their electrical bicycle right there on Ocean Drive. You cannot be a police officer and say you don't see electrical dirt bikes riding on the Drive and electrical bicycles riding on Ocean Drive, because there's 15-year-olds with electrical dirt bikes since last year that has been riding up and down Ocean Drive, and no one has said anything to them. So it would be a blatant violation to arrest me or harass me for riding my bike. So I would like to be all involved with this as well, because I'm not sure why it was divided into two judges at all. And the public defender already looked at the law. If you want to look at the law, based on the fact that my bike has pedals, is considered an electrical bicycle.
all right then. So it sounds to me like you've already raised a misdemeanor, Judge, about your pedals and your electrical bicycle. I myself am dealing with 4 counts of battery on a law enforcement officer, 1 count of resisting an officer without offering to do violence, 1 count of felony marijuana possession, and 1 misdemeanor arresting. So those are the cases I'm dealing with.
Yeah.
Not that whether or not your bike has pedals on it.
I'd like to include, Your Honor, that my older brother passed away because someone hit him off his motorcycle, 2016. I would never run away from the police.
Uh-huh.
And the fact that they waited till I hopped on my bike to try to hit me, to try to build a false narrative like I was evading them, is completely illegal. They waited till I hopped back.
This moment deserves special attention because it highlights a complete disconnect from basic legal definitions. Manslaughter, by definition, requires a death. There is no such thing as attempted vehicle manslaughter when the alleged victim is standing in front of the judge, breathing, talking, and arguing at full volume. This isn't a technicality, it's foundational. But instead of recognizing that flaw, the defendant doubles down, stacking dramatic language on top of incorrect premises. This is a common courtroom mistake among self-represented litigants, believing emotional weight can substitute for legal accuracy. It can't. And worse, exaggeration like this damages credibility. Once a judge realizes a defendant either doesn't understand or doesn't care what words actually mean, every claim that follows gets viewed through a lens of skepticism.
Manslaughter if you were dead, but you are quite chatty for a dead person, so I really can't find that you're dead.
Why did they attempt to murder me? They covered.
Ah, well, that's a horse of a different color. So, what I have to deal with was what's written on the arrest affidavit, not your constitutional arguments, which may very well be filed in a different court on a different day. I have to deal with the four corners of the document there.
Yes, and based on the four corners of it.
Based on the four corners of the document, I'm going to find probable cause on counts 1, 2, 3, 4, 5, 6. And let me ask corrections. Was the resisting without violence dealt with in misdemeanor court or not? Well, that's
I would like to speak, Your Honor. If
Stop!
he,
I'm trying to get an answer from corrections as to whether or not the resisting without violence was managed misdemeanor court or not.
Your Honor, if I have to pay any type of bond, then I will file another lawsuit against this court system.
Well, all righty then. Please feel free to do so. Probable cause is found on counts 1, 2, 3,
And the fruit of the poisonous tree doctrine,
and
that rooted from illegal activity, it cannot be used against me in a court of law.
well, that yes, it's
Understand that you're
the constitutional background for a motion to
law.
suppress evidence that was seized. I read that case once. So counts 1 through 4, the bond is $2,000. Count 5, the bond is just $1,000. Count 6, the bond is just $1,000. Count 7 is an ROR.
Judge Victoria Singular,
I am Judge Victoria Sigler.
not RR.
All right.
I will file a tort.
Here's where things shift from dramatic storytelling into pseudo-legal cherry-picking. The defendant latches onto the presence of pedals on his electric bike and tries to turn that into a universal immunity shield. Then he pivots to equal protection arguments, claiming that because other riders weren't arrested, he can't be either. That's not how equal protection works. Selective enforcement requires proof of discriminatory intent, not anecdotes about DoorDash drivers or teenagers riding by Burger King. Courts deal in evidence, not comparisons made from memory. What's happening here is a familiar tactic: overwhelming the court with volume instead of relevance. The irony is that buried somewhere in all this rambling might be a narrow legal issue, but it's completely lost under repetition, threats, and misapplied constitutional buzzwords.
5A08688584. I did review the report that was completed and filed by DSHS. And does the city want to be heard at all?
City would ask the court to adopt DSHS's recommendations or findings.
Does defense want to be heard at all?
Yes.
Your Honor, we also ask the court to enter this finding, and we also ask the
we
court to withdraw the assigned attorney due to breakdown of attorney-client relationship.
Yeah. And I would like to be heard on the record as well.
The court does adopt the report that was filed by
does the report
DSHS
say?
finding competency in this
Competent.
case.
Is it uncomfortable? Okay, cool. Sweet.
That was by Western, right?
Yes, sir.
I'll check that box.
So now can I go through a full Faretta colloquy so that then I represent myself and you are no longer okay.
We're not going to do that today, though.
Well, I'd like to do that because I'd like to, not have the public defenders involved anymore in obstructing, my rights. And then two, I need.
Seems certain to the court that you need legal representation, so I'm not going to
no,
do that motion today.
No, I don't, because
well,
can you answer this for me? I did a motion to revise the original anti-harassment protection order, and 4 or 5 different judges recused themselves on that. Are you aware of that motion to revise?
That's not before the court here today.
No, but it's really relevant, right? Because there's no probable cause to arrest me and hold me for this charge.
Found Mr. Spidell, so.
Then I will, and hasn't been presented to me. I haven't seen any probable cause affidavit or anything like that. And if you read the motion to revise the original anti-harassment protection order, you would see that there was no evidence in that hearing of harassment. All I did was try to let the prosecutor's office know of Brady Giglio material committed by Crystal Chapel, right? Can you let me speak, please?
You're being recorded.
Yes, I want this to be recorded.
Your being recorded and you're making admissions that might be against your personal interest in this.
No, that's not true because I'm 100. I want the truth to be known. I have nothing to hide. Okay, so
We are.
So you guys are obstructing, though. You guys are doing the obstruction here, okay? So I want this to be heard on the record that I've just reached out to the prosecutor's office to let them know about Brady Giglio material committed by Crystal Chapel, and I was concerned that maybe she would be involved in high-profile cases like the cop that I heard was killed, and I would hate to see anything overturned once this.
This is a perfect example of a legal doctrine being misunderstood into uselessness. The fruit of the poisonous tree doctrine doesn't magically erase charges. It applies to specific evidence obtained illegally, and only after a proper motion to suppress. It's not a courtroom reset button, and it certainly doesn't apply just because a defendant believes police lied. Even more damaging, the defendant contradicts himself moments later about where his bike actually was, undercutting his own narrative. Judges listen for consistency. When facts shift mid-argument, credibility collapses. And once credibility is gone, even legitimate claims struggle to survive. This is why courts care more about coherence than confidence.
No, yeah, this is my case, right? I've been sitting here in jail for 60 days without probable cause.
Probable cause is already determined, sir, so you are not sitting.
It's not a smiling matter. No, then tell me what the probable cause was.
Occurred in this case.
City would ask to set for trial, Your Honor.
We're setting the matter for trial.
Okay. Then, ma'am, I think that you're outstepping your bounds and you're obstructing justice here. Because if you read that motion to revise the protection order, why have 4 different judges recuse themselves? Why did the gentleman just before you just recuse himself? You know, everybody's playing hot potato with accountability, but you're the only one who seems that
And I'm not recusing
you want to break the
myself,
law.
so here I am.
Right, but you're not hearing me.
Oh, I am hearing you, sir. And what you're saying
you are
doesn't fit with the facts of the case. There was
Then
problem,
what are the facts?
and we're moving forward with trial. You'll get your trial on the merits, sir.
Okay, but I know that you guys are just going to dismiss it before trial happens because you don't want a jury to hear about all your misconduct.
Well, I don't mind the jury hearing what you perceive as misconduct. If it's
Okay.
anyways.
All right, then I'm looking forward to that.
If you let us have a moment, we'll set your trial date.
From my calculations, Mr. Speedle has been in. We have Speedy running from November 5th to December 8th when the order was entered for competency. And so after the competency was on today, we're running from, so it was 33 days. We're 33 days into speedy trial. So I believe if we set by January 27th, 2026, we would be within the 60 days.
Okay,
So
No, that's not true because I was arrested on October 28th.
let's see about Officer.
Today's day 59 or day 65, depending on how you look at it.
20th, we don't have a jury because of the holiday, and that complicates getting a jury. And the 13th is
Shame on you.
heard by a protest if it's set on the 13th. So we have the 6th and the 27th, which is pretty close to. You know, the 27th you said is within speedy, so.
I believe so. I'm going by what the jail records say of 11/3 as the booking date.
Okay.
Well, I object, you guys. Didn't you guys swear oaths to uphold the Constitution? Aren't you supposed to protect my rights and not violate them? Why don't I get a speedy trial?
I'm certainly trying to protect your rights, sir.
Well, then why are you even taking me to trial without probable cause? That's malicious prosecution.
I can't keep answering the same issue about probable cause. It's already been.
Well, then can you read to me, for the record, what the probable cause is? Because all in my records, I just see it says warrant, and warrant is not probable cause.
And probable cause is determined before a warrant is issued in this court.
So explain to me then what the probable cause is, why I've been sitting in jail.
And if you would work with your attorney, you would have all of that information.
I am.
This is the moment where the judge gently but firmly brings the discussion back to reality. She clarifies exactly what is before the court: battery on law enforcement, resisting without violence, and other criminal charges, not a philosophical debate about bicycles or constitutional theory. This distinction matters. Courts don't adjudicate feelings, theories, or internet research sessions. They rule on documents, affidavits, and statutory elements. And notice something important here. The judge isn't dismissive. She's focused. But focus can feel hostile to someone who expects validation instead of adjudication. This is where many self-represented defendants realize the courtroom isn't a stage. It's a process.
Tell me what the probable cause is for my arrest.
You haven't granted any motion where you're representing yourself, sir.
Okay, well, I don't understand how you can sleep at night with this kind of misconduct. I mean, like, you know, all your colleagues have you know, passed the buck around, you know, playing hot potato, recusing themselves. And you can't even tell me what the probable cause is. You just say that it's already been established. Well, that doesn't fly.
January 27th, 9 o'clock is your jury trial. Status. Do we set status on the Friday? On the Monday? Your status.
You're obviously not a Christian or a follower of Jesus Christ. I can tell that. And you're going to have to answer for this someday, ma'am. You will be judged.
January 26th at 8:30 in the morning for status. Readiness. January 12th, 8:30.
And what about you, Mr. Good? Where's my probable cause? Where's my discovery?
On the same dates. Correct. All right, out of custody dates for those matters are the same, only at 1:30. I'll put a note in here for that.
Yeah, put that note in there.
Now, obviously, the court wants Mr. Spidell to be represented through a jury trial.
No. I'm going to represent myself.
Only if the court allows it.